Hello, 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 and welcome to another edition of the Consiglieres. And there he is, comes in always waiting to come in and sort of raise the day. That would be Ryan Mulvaney and Philip Sheng. How are you doing tonight, guys?
Hey,
Sorry.
Nathan.
Philip,
Thanks
how
for
are you?
having us.
I appreciate you guys spending some time. We had lots of questions. People have been concerned. I apologize. I was gone last week. I was on vacation. I've kind of felt like a fish out of water watching all this stuff at a distance, wasn't able to talk about it at all. So I appreciate the work you guys have done. I've seen you've been on other people's shows and whatnot. What's your experience been? What do you think the undercurrent is out there? How about the house settlement and everything else?
Yeah, let me start. I owe your viewers an apology. I came on this show a month ago, and I was like, there is no way that this DSA stuff was gonna pass. I just thought there was no way Judge Wilkin was gonna approve that, and I said that the only way that happens is Reggie Miller scores 8 points. I think I used the Reggie Miller. I said Reggie Miller can score 8 points in so many seconds. And it happened. So I was so wrong. So I owe your viewers an apology.
No, I nothing to apologize for. You guys are giving them information they didn't have access to in the first place. So who the hell cares?
And Philip, thank you very much for bringing me back to that awful day where Reggie did put up those points against the Knicks. So
are you a Knicks fan? Let's clear that up right away.
Knicks fan, New York Knicks, New York Rangers, New York Yankees, and
okay,
Giants. So
not much of a front runner then.
Yeah, no,
not going with brands at all. I appreciate you guys joining me today. I know it's been a week now, right? It's not even a complete. I guess this would be day 8 after the announcement last week. The Judge Wilkin came through and she finally put her John Hancock on there. You know, Philip, you thought maybe that wouldn't happen and it would get pushed, but what are some of your first thoughts, going back once you saw the announcement, and then you started, some of these details started setting in on your thought processes? What are some of the first things that come to mind?
I'm happy to go first.
Sure,
I was a little disappointed. Judge Wilkin had made such a big deal about the roster limits. And I felt like she didn't follow through with it. I'll give you just one example, right? Like she made a big deal about how the defendants had prematurely implemented roster limits. She said, that's your own fault, your own problem. Any disruption's your own fault. And then she approved a scheme where they didn't even have to do anything, right? All those, all that harm that they caused, all that disruption they caused, they can just peace out and not do anything. So, I felt like it was a little bit, not a good look for the judge. But, am I surprised that it ultimately was approved? I don't think anybody was surprised that it was ultimately approved. I was a little disappointed, and you know what, that provision, and I'm sure Ryan's going to get into this because I have a lot of questions for Ryan about what he's hearing. That DSA provision was thrown in, cobbled together so last minute that I don't think enough people thought about what that meant. And I think a lot of people, I don't think what students, parents, coaches, the NCAA, and the class council, I don't think any of those people are aligned fully on what the provisions mean. And I'm really curious because Ryan posted something the other day that really sparked my interest, things that he's hearing.
Right.
And I'll let Ryan speak in terms of what he thought about the settlement, but I'd love to get into that right away.
It's not a problem. I have brought up I think this is the primary tweet. Correct me if I'm wrong, Ryan, if there's a newer one, but essentially explain what's going on with this DSA issue.
Yeah, that's the primary tweet. So, and before I hit that, I'll just say I agree with Philip. I'm a little surprised that there wasn't further discussion about the harm that had been visited upon countless college athletes and high school recruits.
Right.
You had a very impressive presentation, and I apologize to her, and I always butcher her last name, but I believe it's Loudermilk, who was a high school senior, who stood before Judge Wilkin in federal court, surrounded by dozens of lawyers, and kudos to her for her presentation. But it was a very heartfelt story, and a very, and I don't mean story in a facetious way. I mean it was her personal experience, having come back from injury and surgeries, to then be blessed with the opportunity to have a roster spot, only to have that taken away in light of the premature implementation of the then preliminarily approved settlement agreement. I thought Judge Wilkin would have told the parties to go back again, because this, I'm not really sure what this DSA process does other than create a lot more confusion, and a lot more, I would suspect, opportunity for litigation.
So is this a new term? Let's just get that out first. DSA, I had not heard of before. Is that a legal term you guys understood before House came around at all?
No.
Okay.
It kind of derived from the, I guess, fourth iteration of the settlement agreement, or I guess the second injunctive relief settlement. So it's kind of found its way into the documents in recent time.
Let me just read your tweet really quick. This was, I guess, what is it, 2 days ago? Yesterday. Ryan P. Mulvaney, I posted the link so everybody can go to it themselves, but it's designated student athletes. Interesting conversations with parents of college athletes this week after telling players and recruits that they've lost roster spots, and that happened before the agreement was finalized. Coaches are refusing to designate these players as DSAs because those players will provide a competitive advantage to the schools to which the players transfer. And if in the same conference or on the non-conference schedule, a competitive disadvantage to the former coach and school, looks like more issues will have to be addressed by courts. It's just throwing gasoline on a fire, isn't it? It's just making it more and more confusing.
Well, this was the very problem with allowing the schools to be the arbiter of this particular process.
Right.
They're the schools are the ones who are, in the first instance, deciding whether or not a student should be, and I'm using DSA'd for lack of the full term, but
right.
The schools are, and it's part of the agreement that in the exercise of their discretion, effectively, they're the ones who are to determine whether or not a college athlete and or a high school recruit who has now lost a roster spot should receive this designation of DSA. And that's where the problem is lying. You look, at the end of the day, this is an inherent conflict. You have coaches are there to win. Anybody who has played a sport knows that the coach's job is to put the team in the best advantage to win games, whether it's football, basketball, softball, whatever it might be, swimming, track and field. So, they're not going to allow a talented and skilled college athlete or high school recruit to go off somewhere else to compete against them.
Right.
The only reason why they're losing their roster spots is because of this roster limitation. There have been some coaches out there who have strongly suggested, air quotes, that a player who is facing the loss of a roster spot should go to play at JUCO, and a JUCO of the coach's choosing, so that the coach can next year bring the player back, almost like a farm system or a system.
Right.
At the end of the day, it's just problematic. You're having, and I go back to it, you're having the schools and or the athletic departments in conjunction with the coaches to make these determinations, which are supposed to be in the best interests of the athlete, whether college athlete or the high school recruit, so that they do not count against another team's roster limits. But here we are, when you're telling someone, well, I'm not going to do it because you're going to be a competitive disadvantage to me if you go in conference and play somewhere else. That's a problem. They need to be able to have this designation, go compete somewhere else, and not count toward that somewhere else's roster limits.
It's a hidden roster spot, essentially. You're taking talent and setting it aside. Philip, you immediately perked up when you saw that tweet yesterday, and you took exception to it. Kind of, what are your thoughts? Because you've been and maybe you too, Ryan, had been a college athlete. You guys you're programmed in your head. You're out there to compete. That's the only thing you care about. Proximity and location doesn't necessarily matter. So what were some of the things that stood out to you?
Well, I mean, first of all, if it's a problem that, your student athlete, your former player is going to play with somewhere else, why don't you just keep them, invite them back? That's my that's my immediate reaction is, and if you're not going to invite them back, there's no penalty in the settlement for coaches over designating. So there is supposedly a penalty for not designating somebody. The judge said, okay, if you think if your student athlete in your school's not designating you, you can contact class counsel Steve Berman and Jeffrey Kessler, and they're supposed to represent you and bring a dispute before Judge Wilkin. But there's no penalty for a school over designating. It just says that a school needs to exercise good faith efforts, right? So, like, coaches, in my view, should be doing these kids a solid. You're gonna cut them. Okay, at least do them the solid of giving them this designation. Allow them to go. Make it easier for them to land on a team. So to hear, was I shocked to see it? No, I'm sure there are some bad eggs out there, bad apples out there who are gonna try to not be nice, not be nice students. But just to see it so quickly, like parents just sort of comment, like, yeah, that happened to me. I think somebody responded to Ryan's tweet right away and was like, yeah, that happened to me. And it's like, oh, really? So this is really happening out there, which is really surprising to me.
So, and we'll get into further details of the House settlement. Let's try to button down and put a bow on the roster limits thing. And by the way, I want to thank everybody for being here. I did a cold open just because I was so excited to see these guys. It's great to see them showing up and spending some time. Philip Sheng and Ryan Mulvaney are both practicing NIL attorneys. They understand how the ins and outs of the system is supposed to work to protect student athletes. And what we're seeing a lot now is organizations, or I would say blatantly the A4 and the NCAA are basically taking these students and playing with them like they're toys, and not really treating them like the people they need to be treated. And honestly, as somebody who isn't in that space, understanding where that fits is really, really important. So I'm glad you guys are here to close that loop. I'm going to let everybody know we're going to go about an hour and a half. These guys both have real jobs, so they're going to have to take off. But if you would like to get a comment or a question to them, it'll have to be a super chat today, just because we have too much content. So feel free to do that. I'll try to get to comments as they come up, but pretty much this is just going to be sort of exploring where we go post House and some of the pitfalls that we have coming up. And I think let's just real quick put a bow on roster limits. You have these students that have been designated or not designated. They can or cannot move on to other schools. The chaos that has brought into the athletic arena, are you guys seeing a lot of anxiety from people that you're dealing with and representing?
I'm getting like eight DMs like a day from parents just sort of not knowing what to do, asking like just for guidance, not even sure if their kid qualifies. I mean, the definition of a DSA is unclear, right? Do you need to be on the roster? What if you were cut before official rosters were announced? What if you didn't enroll at the school? We're getting some clarity on that. I've been posting just some things that I've been hearing. I reached out to class counsel. I have a daughter who's an incoming 2025 who's going to need to make sure she's on that list. So I've been posting information, but parents are freaking out, and was just such a cobbled together system that inevitably, I mean, I think Steve Berman and Jeffrey Kessler are going to get flooded with complaints.
Yeah, I'm hearing and receiving the same kind of calls and emails and texts and DMs. A lot of people are having chest pains right now, and part of that is because there's a 30-day deadline on these schools putting these lists together.
That's right.
What I'll say is, plaintiffs' counsel have been, at least in my communication with them in the past, have been very quick to respond. I had a bunch of athletes from my alma mater, Seton Hall, who had multiple questions about the proof of claim process and like. So in communicating with plaintiffs' counsel back then, I can tell you that they are quick to respond. They're very helpful. I know there's been some chatter out there about people being just disappointed about the fee structure and what they're receiving in light of their work on this. But I will say that they are very, very responsive, and not just in a quick manner, but in a substantive manner. They were able to help. They were able to get the situations resolved. So I suspect both Philip and I will be speaking much more over the next week or two with class counsel on these issues.
Yeah, and folks, I mean, like, look, I can't give folks out there legal advice per se, but if you have questions about just general questions, feel free to reach out, and Ryan as well. I know Ryan's very, very giving with his time as well, so reach out to either of us. I do want to mention one thing. I did have a parent ask me specifically if I could mention or discuss the transfer rules, transfer portal issue for DSAs. So this is my understanding. Okay, I've heard conflicting information, but my understanding is that if you've been cut from your team, that you are no longer on the roster, you are no longer a student athlete. You've been cut, right? So you are no longer a student athlete. You're just a student at this point. Okay, your coach says, hey, Joe, you're off the team. You're a student, and you are free to talk to other coaches. You are free to market yourself and just transfer. You don't need to be in the portal. That's my own understanding. It's different if you are still on the roster, if you are on the bubble, if you're one of those kids who still trying to figure out what's going on. There are tampering rules. That's what the portal's for. You've got to submit paperwork to your school to get in there, and I haven't heard anything that the NCAA is waiving their those types of rules, the transfer portal rules, the tampering rules. I haven't heard anything, but my understanding is if you've been told that you've lost your spot, that you need to that you're free to reach out to folks and market yourself, get on another team. I don't know, Ryan, if you've heard something different.
No, that's how I understand it as well.
Yeah, there's nothing. So, and then the other misconception is that you need to be in the portal to transfer to another school, and the NCAA, I know for that, has come out and said you can transfer at any time, and then be immediately eligible. There was gosh, I forget the name of the kid who did it. Was it Florida? One of the Florida schools, I think. But they just got up and left. Went there for a semester and said, "Hey, I'm out of here. Peace out." Joined another team, and then and was able to immediately play. And folks are wondering, well, how is that person able to just transfer without being in the portal? And the NCAA came out with a statement that Ross Dellinger reported, and the NCAA was like, well, none of our rules really prohibit what this person just did. So anyways,
okay, so now let's jump right into some of the stuff that was announced right after. Monday morning, I believe it was 9 a.m. Eastern time, something to that effect, was the first Title IX lawsuit charging. It wasn't announced for some reason until Wednesday, but that actually came out Monday morning. It didn't surprise anybody that lawsuit was coming. Maybe it might have been a surprise on who ended up filing it, but where do we go with Title IX? And I am not expecting to cure cancer here today, right? We just want to be as short and sweet. If you guys think that Title IX is just going to be a mess and there's nothing to talk about, I'm okay with that too. But I'm getting people up and down sending me messages saying you need to chase down this Title IX thing, and I don't know where to live with that.
Yeah, it's fine. I actually one of my tweets, so I think right before that, or X posts, or whatever the hell we're calling them nowadays,
Right, whatever. Yeah.
addressed the Title IX issue, and took some information from one of the, I believe it's a nonprofit, charged with the responsibility of addressing these Title IX issues. And I'm not sure if it was an affirmative case or if somebody appealed this. I'll have to double check that, but I thought it was somebody appealed this ruling, this grant of final approval.
Right.
So we'll see what the circuit court does on that issue. But the claim there is that, or the issue on appeal is that the distribution of back damages under the settlement violates Title IX.
Right.
Substantial amount going to certain sports and not enough going to other sports. I think there's like $1 billion shortfall there between men's and women's sports. So yeah, it's going to be look, as we all talked about weeks ago, the House settlement, just because it obtained final approval does not mean it's the end. This is just the beginning, and we're going to see more and more appeals. We're going to see more and more lawsuits filed. So this is just the very beginning here.
Yeah, it'll be interesting to see. It was an appeal to the approval of the House settlement. Judge Wilkin did not reach the merits of those claims when the objections were filed in the first instance. Her view was that the settlement settled antitrust claims and not Title IX claims. So Judge Wilkins' view was that she didn't have that controversy in front of her. This is an antitrust case. I'm here to resolve an antitrust case, and if the parties want to settle this case and that's how they settled, then that's what I'm going to do. She expressly said, the Title IX claims, that's a different lawsuit. Now, if folks want to bring a Title IX lawsuit, they can. What's interesting to me, that I think that the most interesting argument, right? So for people who say that it does not violate Title IX, like the bucket of people who say it does not violate Title IX, their primary argument is that, okay, well, it's based on how much revenue your sport generates, right? So they're going to say, okay, well, football generates 80% of revenue, so we get to pay 80% of the pot to football players, and we'll say 15% men's basketball will pay that. The counter to that is that historically, and I really wanted Judge Wilkin to reach this issue, but she didn't. The counter to that is that historically, schools and the NCAA, they haven't really promoted women's sports. And I'll give you one example. Okay, so it wasn't until 2 years ago that the NCAA allowed the women's March basketball tournament to use the trademark March Madness. So historically, only the men's tournament could say that they were March Madness.
Really? I didn't know that.
Yeah, the women's tournament had something else. Like if you notice, if you paid attention, like they always referred to the women's tournament as something else. Like, oh, we're now here like the March, women's championship or whatever language. It's very intentional. And it wasn't until a couple of years ago that they allowed the women's tournament to use the March Madness branding, and then people started hearing like, hey, Caitlin Clark and Angel Reese, right? And it became a big deal. And for that year, the women's tournament, the final game, the championship game, the viewership exceeded the men's tournament for the first year ever, right? And that coincided with the women's team being able to use the March Madness, the women's basketball being able to use March Madness. So the argument is that historically schools and the NCAA hasn't really been promoting women's sports, and there's some merit to that. I mean, I have daughters who play sports. I can tell you that at some level, there is some truth to that. And that there's a little bit of a chicken egg problem, right? Like some people will say, well, the reason we don't invest is because they don't generate revenue, or they're not,
right.
And then the other side will say, well, the reason they don't do that is because you don't invest.
It's because you don't invest in it. Yeah.
Whatever, right?
Yeah.
So it's I really wanted her to reach that question, and she didn't. But I have heard that, and I've read that on July 1st, when the revenue sharing portion of the House Settlement goes into effect, there's a very prominent Title IX lawyer who's already stated that he's got clients lined up to sue schools over Title IX. So I would not be surprised on July 1st we see these lawsuits filed against schools for the future revenue sharing based on Title IX. We'll see. It's gonna be wild.
Thank you for clearing that up. You're right. It was an appeal, and I got the term wrong there. So thanks for setting me straight.
So the appeal is appealing the back damages, like the 2.8
that was my next question.
Back damages. Like how do you the distribution of the $2.8 billion going backwards? The suits you see on July 1st are going to be against the schools themselves, not the NCAA, not the conferences. On July 1st, you'll see lawsuits against schools directly, because the schools are the ones with the purse that they're going to be distributing their $20.5 million.
So let's just clear that up, and then I do have a super chat or two that I want to get to. So now that the settlement with the A4 Power 5, right, is still on there, that lingo is still they're attributing Washington State and Oregon State to have the same costs as all the other conference schools. It is about the money that the individual schools have and what they do to distribute it. So school X gets $20.5 million. They could give it all to one kid, or they could spread it out across multiple sports. Title IX charges then would be, hey, we expect a certain amount of that to go to, whether it's women's basketball in particular or all female sports will get a percentage of that. Do we anticipate those getting real messy? Can they be put into a class action? Could you see schools being charged as an entity with the conferences? BYU and Utah women's get together and they decide they want to sue not just the universities, but the conferences for getting to where we're at right now. Is that even a possibility, or is it only the schools?
For a lawsuit over, are we still talking about Title IX? Are we talking about
trying to get part of that $24.5 million per school for women's sports or women participants in general?
Golly, I don't know. I mean, Ryan, why don't you take that one, Ryan?
So you mean on the $20.5 million revenue share?
Right. Yep.
I mean, look, potentially you may have some disgruntled athletes and not just women athletes, but male athletes in other sports.
Right.
They may say, well, we're deserving of more too. On a class basis, potentially, you could certainly have a class of women athletes at a university against the university itself. I mean, how many? You've got at least 15 on a basketball roster right there. You've got however many on women's softball, women's golf, track, swimming. You could have a class of some of those people. They'd have to obviously satisfy the factors for class treatment, but
right.
I wouldn't see why that couldn't happen.
That's extremely messy if it could get that big. Sure. I can understand one kid charging one sport. It's difficult when you start talking about Olympic sports, some of these extracurriculars that these universities have.
Yeah, I mean, I think the biggest, because there could be Title IX issues. You mentioned BYU and Utah women's basketball, right? That's they could say Title IX. Right. I see more likely a lawsuit with respect to the revenue share cap. So $20.5 million. I mean, look, in the abstract, that's a ton of money. But when you think about how many sports some schools have, like 30-something sports,
right?
We've got to get the star quarter. We've got to take care of the quarterback. We've got to take care of the football team, basketball team, right? And so you've got $20.5 million. That's across every sport and every athlete. So just functionally, you pay, so much to these athletes, it caps how much, someone on the women's basketball team could make. So that's where I would see lawsuits coming is just against that cap.
Okay.
Because let's say there's a women's basketball player who's Caitlin Clark who deserves $1 million a year, but school just doesn't have that money because they've got to feed their basketball and men's basketball and football team. So I think that cap is where that would come in. At least that's how I'd approach it if I had, if I was a lawyer. I don't know.
So if I was a lawyer, that's right.
If I was the lawyer, they came to me and asked me. I don't know. Please, folks out there, don't reach out to me. Start asking me these questions.
When people started finding out about the House settlement in the last, year or so, people have really gotten involved and tried to understand what is revenue. If you're a school that's a debt center, in other words, you cost the school to put people in uniforms to go represent in your particular sport, cross country. You're not making money for the school, so why should you get a piece of the revenue?
Well, in those circumstances, I would think the school may not opt in. Right, there are some schools that have and some that haven't. So if the athletic program is a loss leader in terms of revenue, then I don't think I would, as an athletic director, would want to opt in to then compel the program to have to share revenue with players that were not earning for the university.
Right. Yeah, I don't know. These are questions that are just going to continue to sort of float around until we get more and more clarity on over time, I think would dictate that. Let me get to a couple comments. First of all, Jason Spangler said hi, gave me $2 to do a super chat. Appreciate you being here, Jason. It was great to see you last night. Ryan Willie, one of both Jason and Ryan, valuable members of the College Football Mafia family. Appreciate you guys and your loyalty. Question, will the NIL deals be binding? The ones that were signed before approval and now after? Or do they have to, even though they were written before anticipating, are those same contracts still valid or do they have to re-execute those?
Yeah, so first of all, Ryan, great name. So yeah, that's why everyone was trying to front load a lot of
right.
These, right? So anything that has been signed, if you're an NIL collective and you're engaging with a player today and you sign that player tomorrow to something in excess of $600, those contracts will have to be reviewed and go through the College Sports Commission and go through Deloitte for the vetting process.
Right.
Anything before that is you don't have to go through that process, and also the revenue sharing obviously doesn't have to go through that as well. They just have to make sure that they're not exceeding that $20.5 million cap.
Okay, Philip, do you have any other comments on that piece?
Yeah, no, I know that what Ryan said is correct. I'm curious to see whether current revenue sharing deals are binding. I've seen a few of the agreements, and they try to dance around. Okay, this isn't pay for play. This is for your name, image, likeness. Right? There's some language. It checks all the right boxes. But it'll be interesting to me to see if a student athlete, midway through the semester says, you know what, this wasn't a good fit for me, and then just and transfers to another school. It'll be interesting for me to see whether a school will try to enforce that agreement. Will actually start suing athletes, whether there's buyout clauses that will be enforced.
Right.
I've heard schools experimenting or playing with the idea of doing multi-year contracts.
Right.
So all this stuff is just so new. We don't really have good data points out there. And like the pro leagues or like with coaches, like we have a lot of data out there. A lot of lawsuits have gone through. We know sort of how courts are going to handle it, but whether schools go to the mat and with these student athletes is going to be really interesting to see, and how enforceable these contracts are.
Yeah, and that's really from an athlete perspective. That's really the necessity to have these agreements reviewed by lawyers like Philip, like me, like some of the others that are notable out there. you have provisions like clawback provisions. You have, and not just a clawback of some funds, but a clawback of all of the funds should you dare enter the transfer portal, which, by the way, is an express right afforded to athletes under the bylaws of the NCAA. So you really need to have these contracts reviewed, not only the clawbacks, but I've come across an instance where a school who will not be named, as much as I'd like to, because of this egregious process, but I will not.
Don't say St. John's.
No, definitely not St. John.
Okay.
Good Big East.
BYU. No, don't say BYU either. It was not BYU. I can tell you that.
Yeah, I'm sure it probably was. Go ahead.
So a school, a player wanted to exercise the right to enter the portal, and was presented with a release that included a non-compete, suggesting that the athlete could not play at multiple other schools and multiple other conferences.
Is that legal?
No, of course not.
Okay, doesn't sound right to me.
But as Philip said, you'll see more and more multi-year deals. I'm actually in the midst of negotiating one now. And from an athlete perspective, I don't necessarily mind multi-year deals when you're an upperclassman, right? You're a junior, you're a senior, you want a little bit more stability, as opposed to kind of bouncing around year after year, entering the portal and shopping yourself around. I mean, obviously, it's a case-by-case, player-by-player basis. You'd have to take a look at that, but I'd be more in favor of being presented with and executing multi-year deals as an upperclassman rather than a freshman.
I believe it was Jay Billis who posted that comment about buyouts in the not that he invented it, but he did encapsulate it in one tweet yesterday, and that it would slow down transfer portal activity in general, meaning you sign a multi-year deal. There are buyouts, yes, to leave. That means you'd have to give some of the money back that you were due and whatever that time period would be. But that this is going to not prohibit, but really inhibit the ability of these athletes to jump from school to school. What do you guys think about that? Philip, what do you think about that idea of now this is going to constrain trade?
I think most schools will structure their payments to be like, I don't know, monthly or I don't know, every quarter or something. That fixes some of the problem, right? The problem usually arises where you do a big lump sum and then
you get it up front. Yeah.
Then the athlete says, I'm out of here. Then there's the issue of, well, how much do you have to give back?
Right.
Buyout clause might touch on that, but I still struggle that these agreements are supposed to be for a player's NIL. That's what the agreements all say. I mean, we all know between us friends, it's all pay for play. Like, we are paying you to come play for us.
Yes.
But the contracts say that they are for your NIL, and I'm really curious how much, are schools really requiring athletes to go on, I don't know, promotion events and wear certain, I don't know, school clothes and show up to places? I mean, like, how much of this really is NIL? And then so if we're in this world which is really for pay for play, and how do you value that? I just don't know how you value it. You're gonna allege that the contract was breached. How much does that athlete owe? And the contract says NIL. We all know it wasn't really for your NIL. Like, what happens? How does a court determine how much money really needs to go back to the school? I don't know.
Yeah. You want to add anything to that, Brian?
No, I got a chuckle when Philip said this is not like, let's not pretend here that this is really about name, image, and likeness. These are actual playing contracts.
Right.
Schools are negotiating with players, no different than I negotiate with NBA teams on behalf of NBA players. This is the exact same thing. And those contracts have subsumed within them appearance requirements and media requirements and all that type of stuff. The only difference is those contracts in the NBA have effectively been collectively bargained.
That was my next. Okay, keep going.
Right? Here it's just, whatever contract you get, and then it's up to people like me and Philip and others to just rip them to shreds, redline them, and do the best we can on behalf of an athlete client. So, and I have this discussion with NIL agents too, where they try to take the exorbitant percentages of these revenue share contracts and the NIL collective contracts, and their position to me is, well, it's a marketing agreement. And I know this is a family show, so I won't get into exactly what I say back. But
no, go ahead. I want to hear it.
I mean, it's horseshit. These are no different than your playing contracts, right?
Right.
So if you're dealing with a basketball player, take your 2 to 4%, not your 15 to 20. Let's not really, take money out of the athletes' pockets here under the auspices that these are really marketing contracts. They're not. They're really not at the end of the day. That was my couple minute soapbox on that. I'm glad.
Oh, that's okay. No, I appreciate
it. That's something that bristles me all the time when I hear people say, "Well, they're marketing contracts." No, they're not. No,
you want to get me going. We'll talk about collective bargaining, because I think collective bargaining or even employee contracts, some way to put these athletes in a position where they can protect themselves. Right? These, at the end of the day, they're young kids, and requiring them all to go and get a lawyer to negotiate $1 million contract, yeah, that makes sense. But some of the dollar amounts that we're talking about here, it seems kind of childish and silly. And now we've got this movement in Congress, where they're going back. The NCAA and the A4 are going back, hat in hand, saying, please, please, please protect us. Do everything you can to protect us from ourselves, even though for 70 years we've been taking advantage of student athletes and never thought a whit about paying that money back. So where do you guys think we go with the collective bargaining and this idea that either these athletes have some sort of way to protect themselves versus just the rape and pillage that you'll get from hungry corporations, which, I don't care who you are, these schools are not necessarily profit centers, but they are benefiting from athletes that play for them.
Yeah, so I'm not, I'm not a pro on this collective bargaining issue. My understanding is that there's a threshold requirement, right, that students need to be employees. I think that's right.
Yeah, that's right. Yeah, it's associated.
Right,
yeah,
correct me if I'm wrong, but I think there's this threshold requirement, and there's some problems there between whether private schools versus public schools can be employees and form unions and stuff like that. I'm not a pro at this, so I'm not going to pretend like I know anything about it. But I will say this, right? So I played tennis in college. Okay, so like I was a D1 athlete at Stanford, played tennis in the early 2000s. I never thought I was an employee. Like I showed up, to work because I loved the game. I loved my team. I loved, I chose to go there to play a particular sport. I never felt like I was an employee. Sitting here today, looking back, do I feel like I satisfy all the tests that courts have created to determine whether you are an employee or not, right? Did the school have control over my schedule, my practice, how many hours, where do I go, where do I travel, what do I do, what can I eat, what can I, whatever.
Yeah.
Looking back, I'm like, sure, I check all these boxes, and maybe I was an employee. As a tennis player, like, never occurred to me like I would have wanted to be an employee. I think like if I was an employee, I would have, not enjoyed it as much. It really would have felt like I was going to work, right?
That's fair.
Like, you never really want to feel like, whatever you do, whether you're an athlete or in your professional life, you never really want to feel like you're going to work, right? You want to tell yourself, I'm going the opposite. I could do what I love to do today, not because I'm going to work. So as a tennis player, I think, I probably view it differently than a football player who is making the school gazillions of dollars. Like the tennis player, look, we don't generate much revenue. I mean, it's reality. But I could see like a football player thinking like, oh, I just made my school a gazillion dollars. How come I don't get a piece of that pie? One problem I see with collective bargaining, and again, I'm not an expert at all this, but the interests between athletes are not going to all be aligned. the tennis player and the football player, those interests are not going to be aligned.
That's fair too.
So what I want versus what someone else wants, that's going to be a problem, I think. But that's my soapbox. I don't know if Ryan, you have anything to add to that.
I appreciate that.
I agree 100%. You have, people in sports with obviously different, views on it, but also different interests, and they do not align, all the time. Just as Philip mentioned, he played tennis. His viewpoint, back then, but if he played tennis today in college, would those interests be the same as the football player or the basketball player? Perhaps not. And I'm no, expert on labor law, although we do have, as Philip's firm does, I'm sure, labor lawyers within the roles. But I have, a very basic understanding of the limits of the National Labor Relations Act and the National Labor Relations Board. And, I'm not sure you can have collective bargaining across all of college athletics. There are exceptions. I mean, the NLRA, as I understand it, applies, purely to the private sector, but we have public schools, right? And we have, as opposed to private schools, and we have religious-based schools where the NLRA wouldn't necessarily apply. I do think at the end of the day, something needs to govern on a standardized basis. I think everybody should be on the same playing field. I think everybody should have standardized agreements. I think everybody should have, whether they're revenue sharing agreements or NIL agent agreements, I think there should be some uniformity across the board. That might solve a lot of the problems that Philip and I are seeing as we sit here.
Yeah, I mean, the power between the A10 and the Big Ten, they're in different universes, right? Sure. And yet I don't know about any A10 schools that opted in or didn't opt in, but they're in no way, shape, or form can you put them on the same piece of paper and say they are just stare and compare equals. There's different revenue models. They have different media deals. So there are major complications when it comes to that. And yet I think it's really important that we understand that forever and a day, these students, and Philip, I'll throw you in there, they showed up for a badge, right? The S on your jersey, the Seton Hall, SH, that, if you show up and that's the pure love of the game and that's all you care about, there's nothing that forces you to impose yourself to ask for money, right? There's nothing that makes you a part of the operation to get revenue sharing or get NIL or even the intellectual property, if you just want to call it that. Whatever it takes, if the school's using it, if the conference is putting you in videos to promote the sport, there needs to be some accountability there. And I just don't think right now, in my opinion, it doesn't seem like there is a ton of fairness when it comes to the unequal events. Point forward at Seton Hall is not necessarily point forward at Alabama. So these are questions that will continue to come up. Let's talk procedure really quick. Oh, sorry, go ahead.
I mean, and you're right. And to that point, look, I was not lucky enough to play college sports. My athletic ability peaked in high school. Truth be told, I played hockey, I played baseball, I played golf. So it kind of, it peaked, my senior year. So, but as I walked the campus at Seton Hall back in the early to mid '90s, if I was a college basketball player, despite the fact that I have zero left hand, I don't know if I would have even thought, well, gosh, I could be earning revenue. I mean, the athletic department, the school's making money off. I don't even think the money was really that I'd have to take a look, but
I don't know. The Fab Five is exactly the time for it, and they came in and they looked at it completely opposite. They said, "You guys are making bank on us.
Yes,
You're selling a nickname. You are exploiting us as
yes,
individuals and humans,
yes,
and we're not getting any of it,
yeah,
right?" And then we find out Chris Webber, and they're getting paid some. And anyway, I
that's
didn't
where
mean
I
to
was
interrupt
going
you.
with it.
Allegedly, they were getting paid some.
It's you're starting to realize, well, wow, they're making a lot of money off of us, and that's really where that. I guess if you want to pinpoint it for basketball, I mean that's maybe with UNLV to running Rebels back.
Right, same thing. Yep, that's right.
At some point, it's like, well, the light bulb, went off, and you had a lot of the Fab Five, or look at SMU back in the day. It's the reason why they got the death penalty, because money would find its way into the hands of players.
It's gonna come back, you guys. It's coming back. Ryan, I saw you posted something the other day about how we're returning to the days where Uncle Leo shows up with a brand new car somehow. I think we're going back to those days. To be honest with you, I think this Deloitte thing's going to be a problem. I think there's no transparency into what how that thing's calculating and
what is fairness. What is fairness?
What is fair?
How do you define that?
I'll tell you, fairness starts with transparency.
Right.
It'd be great if folks knew what it was, what's algorithms were doing, how much weight it was giving certain things, how much what factors were most important. Right now you just have athletes going into basically filling out a Google form. It looks like you plug in some numbers, plug in how many
Yeah, you're talking about the NIL Go page.
The nil go, which is funny because in Britain, nil means zero in sports. And so, I think we are going to see the return of the bags of cash, the brown bags of cash. I just think it's been, we've tasted the forbidden fruit in the last 4 years, right? So 2021, before 2021. There was a cap of zero. You couldn't pay anybody anything, and then for 4 years we sort of tasted the forbidden fruit of really just this arms race of trying to pay.
Well, it's free market, right?
Free market, right? What is fair is what someone's willing to pay you, right?
Exactly.
And then so now we're back in this world where we have a cap again. The schools get to pay $20.5 million. That doesn't need to go into the nil go system, which is, to me, it's like, why does a school get to pay someone 20.5? Theoretically, pay a single player 20.5 million with no scrutiny whatsoever, and then when a collective wants to, not even anywhere close to that, has to go through, get it cleared by this clearinghouse, and we're going to see problems. The problem is no one knows about the underground world. That's why I said allegedly with Chris Webber. I don't think with Chris Webber he's ever come out and said, yeah, I did it, right? Or I got paid, right?
I don't know. Did he? He had a settlement. He said I made mistakes, or I don't know.
I don't know.
I haven't watched Fab Five for a while. I should watch it again.
I'm not sure he actually admitted it, but
I can't remember.
You might be right. It's been a while since I've seen that as well. Just the fact that we're referring to 5 players as the Fab Five is just a reflection that truly they did have name, image, likeness, right?
So and even after that, and I'm watching some of the comments go on the side here, and I see that there's a lot of disagreement with some athletes getting paid, and I guess I understand that. There's obviously both sides to this issue, but look, at the end of the day, the college athletics world emanated from the Supreme Court, right? They said that there's value in the name, image, and likeness of a player. It's intellectual property rights. But even before you get to college, I don't know how many of you follow basketball, and even high school basketball or youth basketball, even before high school. But, in New York City, 10, 15 years ago, there was a massive, maybe a little bit longer, there was a massive movement by, I don't know, maybe 5, 6 kids, grammar school into high school kids, Jelly Fam. And it took off like wildfire. And not just in the New York City area, but everywhere. When kids go up to do a layup now, you'll hear them shout in the gym, jelly, because that was like their thing, right? Back in the day.
Right.
These were high school kids. But for them to earn compensation and trademark that name and earn money while in high school, they couldn't even do that because they wouldn't have been able to play college athletics because they're no longer amateurs, right? So there's two sides to the issue. Look, I debate this all the time with folks who are not necessarily supportive of athletes, earning compensation based on their either name, image, and likeness with collectives and third-party brand deals, or through the revenue sharing with the universities. But I am supportive of the fact that, and I acknowledge the fact that, and maybe I didn't back when I was in college, at Seton Hall, I didn't, process the fact that a lot of the guys that were there were earning money for the university, earning money for the conferences, earning money for the NCAA, despite its nonprofit, quote unquote. But at the end of the day, they're bringing, and this is what I was going to mention before, they're bringing billions and billions of dollars into the industry. No one is turning on the TV to watch anything other than these athletes.
Yes.
Not a single person watching this, not the three of us, no one is turning on a game to watch a coach, to watch a referee, to watch the fans sitting there. Because if it weren't for the athletes, there'd be no coach, there'd be no referees, and there'd be no fans. And the fact that they are earning billions and billions and billions of dollars, media rights and the like, sponsorships, that's coming off of the backs of the athletes. And yes, they're earning, or they're receiving scholarships to attend school, for free, athletic scholarships. But at the end of the day, that pales in comparison in I think a majority of the cases where you have football programs or basketball programs generating untold millions and in some cases billions of dollars for the NCAA and the conferences and the schools. I mean, look, these media rights derive from the Alabamas of the world on the football field, the BYUs of the world on the football field, the Kentuckys and Dukes of the world in basketball.
Yeah.
That's why we're turning on the TV. I mean, now we have conferences have their own channels now, right? You've got the SEC conference, the Big Ten conference. All of this is as a result of the work of the athlete. No one else earned it but them. And it's also that side of it that I see as well. And because it is now something that has been thrust upon the industry as a result of the Supreme Court decision, we're not going back to the way it used to be. We're only going to be moving forward, and we need to figure out the best way to move forward for the benefit of everyone. Whether everyone being the athlete, the schools, the NCAA, if it still exists.
I like that. If it still exists, yeah. It might be bankrupt.
That's what we need to do. And I very much appreciate the dialogue on the bottom right here. They are certainly active, and I'm hoping I'm responding to a few of them.
I would tell you this: I don't care what other shows you guys will do. The people that view my shows here are the smartest ones you're going to run into. So they're going to ask you the most insightful questions. They'll have the most specific and direct statements. So don't take it personal.
Oh, no.
If you see something on there that they're not attacking or even gainsaying anything you guys are saying. They're literally trying to engage and be involved, and I really appreciate him doing it. Daniel Gygax is a contributor around here, as well as being a valuable member of the College Football Mafia family. I'm going to give this right to you, Philip. How will international players work? I know it's been an open question.
That's a great question. So I'm not an immigration law lawyer, which I think there are folks that specialize in immigration law with respect to college athletes. But it's an open question right now. So like my understanding is that if you're here on a visa, you cannot. There are restrictions on whether you can work, like what you can do as a job, and so under the prior to the House settlement, under the old regime where you had collectives paying out, my understanding was that was not allowed. Collectives weren't allowed to pay international students on visas if they were in the United States. That the rules changed once you step outside of the United States. So that was one way folks were getting around that, was that there's an example of a player who Kentucky went during the Bahamas basketball tournament. That's where they did all their NIL deals.
Is that right? Working around. Okay.
Yeah.
I hadn't heard that.
And then there's if you go back to your home country, as long as you are in your home country, they'll fly out to you to do your photo shoots or whatever.
Wow.
I'm not sure what Charlie Baker came out the other day, said that revenue sharing, schools could share revenue with international students. I don't see the difference between whether the money's coming from a school versus a collective. If you couldn't do it before, I don't see how schools can get around it. The tricky part is in the law we have something called strict liability, which means like doesn't matter if you're speeding in the car, doesn't matter if you intentionally sped or you did it by accident. It's a strict liability. Cop pulls you over and says here's your ticket. This sort of taking money and violating the immigration laws. If you're on a visa, it's a strict liability offense. Like doesn't matter if you thought it was okay, if the school told you it was okay or whatever. If the enforcement arm comes out, and I don't even know who enforces, what department of the government will come and knock on your door, what agency knocks on your door. Doesn't matter if you thought what you're doing is okay. If you didn't, you could lose your visa. So that's the extent I know about it. And that's I'm not an immigration lawyer, but it is an interesting issue that I've been following. I just don't, that's the best I can do.
If you're a BYU fan, it's a huge deal because they recruit players from all over the world, part of the faith. It's one of the pulls, and it definitely is going to affect us around here. Ryan, do you have any insight in the international player?
No, not anything above and beyond what Philip said.
Okay.
Yeah, that's how I understand it as well. I mean, look, at some point, Congress is going to have to act and do something on that respect. Obviously, Congress, that is pushing forward on, various pieces of legislation trying to get something done. But I think, look, just from a fundamental fairness aspect, I would think, international athletes should be able to share in the same revenue that they are generating as well as their teammates.
Sure, absolutely. Yeah, I think talk about fair. That would absolutely have to be fair. Okay, we've only got a half hour left, a little less than a half hour actually. We're going to be strict on time today. So if you want your comment or a question to be read, it'll have to be a super chat. Been like that all show. There's only so much we can cue these guys with, and so I just want to make sure everybody has that opportunity before they leave. We will be doing more of these consigliere shows. I've got 2 of them here. I think the total number I'm up to is 19 people, and you guys have been in that group. How impressive has that group been for you guys to share ideas and sort how things are running without being exposed to the entire world?
Yeah, it's like a digital conference room. It's great.
I love it. I know I invented it, so I'm patting myself on the back. Okay, so we'll try to get through a couple more questions here. Let's talk about this special master guy, or whatever his title is, that Judge Wilkin said, don't talk to me anymore. I signed this thing. You guys have any issues, you now deal with my accountant, or I don't know, the guy takes notes, or whoever he is. Can you, because that was dropped in an announcement and then nobody's talked about it since. I'm just curious, who do people take things up with now?
Yeah, go ahead, Philip.
Oh, I was just going to say, no one's talked about it probably because it's pretty normal, pretty standard.
Oh, okay.
Yeah, it's so you have your district court judge who is an Article III judge confirmed by the Senate, and then you have magistrate judges who are not confirmed and with advice with Senate, whatever the Constitution says.
Okay.
And so these magistrate judges, they really handle like discovery disputes. They handle, they're not the ones with, really in the substance of the case often. So they handle mostly discovery disputes. They handle, the parties, fighting over, small stuff.
Okay.
So, with Judge Wilkin, I've heard she is very close to retirement. She's already seen
okay.
that. So I've heard that the House case was really going to be her, her defining, legacy moment and get,
Right.
rule on this. Then, I wouldn't be surprised if she throws in the towel in the next few months. Honestly, 6 months. Probably wants to see make sure this thing, pans out how she expected. But yeah, so it's basically like, Judge Cousins, very honorable, very well known, well respected magistrate judge in Northern California. He'll be handling like the DSA issue.
Okay.
I imagine he'll be in charge of that if Berman and Kessler, feel that they have the obligation to litigate on behalf of a DSA. I think Judge Cousins will be the one who decides that.
Okay. Brian, you want to add anything to that?
Yeah, it's not like Judge Cousins is a brand new judge who doesn't know anything about this. Typically, you have, as Philip said, your district judge who handles all of the dispositive things, and then your district judge is typically assigned to a magistrate judge, and they work together on these cases.
Okay.
Not just this one, but all the other ones that they have, whether they're breach of contract or you name it. So they typically work hand in glove. The magistrate will resolve all of the preliminary stuff, as Philip mentioned before, the discovery disputes, but also largely responsible for holding the settlement conferences between parties. So this is ordinary course type stuff.
Okay.
Appearing before magistrates on things like this, and having the magistrate appointed as the special master, this is ordinary.
I hadn't heard of that before, so I thought some people could have questions about it. So I appreciate you answering those for me.
Yep.
Devil Frogs, the original, the OG Mafia member. Thank you so much, Devil Frog. $5 super chat. I appreciate you and everything you've done for us. Okay, next question is, so what do you think the next lawsuit is? If we assume back payment, Title IX are already filed, or they're appealing, as Philip said, what's the next lawsuit that you would anticipate at some point here pretty soon? Don't we have to have at least one person stand up, put their hand in the air and say, I don't agree with this fairness thing that you're doing for payments on NIL? Like, what's fair in California isn't necessarily what's fair in Kentucky.
Yeah, I would anticipate suits for those several hundred athletes who opted out of the settlement.
The individuals, right?
The individuals.
Yeah.
I would assume that they would commence their own lawsuits.
Okay.
But as it relates to this new College Sports Commission and Deloitte blessing the third-party NIL deals, and by that I mean your NIL collectives and your third-party brand deals. Yeah, I suspect there'll be lawsuits there too. Look, if an NIL collective or a brand deal wants to pay some exorbitant amount of money to have someone sponsor their product or to appear at an autograph signings, so be it. That's the business judgment or lack of business judgment of the company and the collective. But now we have Deloitte, who will be thumbs upping or thumbs downing these third-party brand deals and these NIL collective deals. So I anticipate some litigation to come out of that as well.
Philip?
Yeah, I think Title IX will hit July 1st. I think on July 1st you'll have Title IX lawsuits against specific schools, and then I think the clearinghouse, the Deloitte clearinghouse is next. The clearinghouse, it has some interesting issues. There's a mandatory arbitration provision for the athletes. So athletes who aren't satisfied with what Deloitte says, they need to go through arbitration. So you probably won't see a big lawsuit hit the news, but I think they will be filed. I'm curious to see whether collectives sue the clearinghouse. Based on the clearinghouse, it's sort of an interesting situation, right? Like you have a car dealership wanting to pay $10 million for someone to show up to your car dealership, and Deloitte says no, and then the college commission says if you go through with it, the athlete might lose eligibility, whatever the punishment is. It's like it just seems weird to me for like a car dealership to file a lawsuit against the College Sports Commission to say, hey, you didn't let me pay this guy $10 million to show up to my car dealership and I don't know, sign some autographs. It would just be like a weird lawsuit to file, but it will happen. It'll happen. The clearinghouse stuff, and then the antitrust of 20.5 million cap. I think is future students could start as well as I don't know. Is it next year? Or, yeah, next year.
It says 25, 26. Yeah.
Yeah.
I don't know. The clearinghouse, NIL Go, the whole fun. By the way, did you actually go to the NIL Go website?
I have not visited it yet.
Okay.
Yeah, I've been on it. Yeah.
The screenshots make it look like it's an old Flash production from 2005, 2006.
I saw screenshots of it. My first reaction was Craigslist. I was like, oh,
yeah, it's about right.
Who put Craigslist
That's about
together,
right.
The NIL Go website together. I use Craigslist all the time. I don't know what that means, what that says about me, but
I think it just says you're a good bargain hunter, is what it says.
Yeah.
So we will continue to have these conversations. We'll continue to have these consigliere shows. You guys coming on and giving your time, I think, is really important. I hope everybody appreciates that. My last question, and then I'll let you guys go, revolves around what is the next steps? Do we believe by the end of this year, in your opinions, obviously, and then give your reasons if you wouldn't mind, that congressional support comes in? Or it just doesn't get across the line, and we make it, and now we're rebuilding the temple next year.
Rebuilding the temple like that. Ryan, if you don't mind, if I go first on this one, just because I've got to jump off, you guys.
Sure. I know you got to go.
Look, I haven't been following it too closely, and I've heard over the last decade or so that they've tried, and after the House settlement was approved, you got a lot of buzz that, hey, there's some action, there's some movement going on there. But there was a hearing yesterday. I listened into a little bit of it. I saw, the Twitter news on it. I read a little bit about it. It seems to me that nothing came out of it whatsoever.
Not much.
That there was a lot of, partisan, butting of heads on that issue. So I don't know. But hey, I've got to drop, you guys.
Thanks, Philip. I appreciate it. Thanks for coming on today.
Ryan, it's great connecting with you finally on one of these shows, man. And we'll keep in touch over Nathan's super secret private chat with all of the various folks.
All right, you can email offline too, because I know one of your colleagues fairly well. So we'll
okay, for sure.
Have a great weekend, Philip.
All right, bye, guys.
Okay, all right, Ryan, you get the final word. Do you think congressional support is finished this year, or because it's not bipartisan by any way, shape, or form?
It's just it all seems so performative.
Yeah, that's what I thought too.
Everybody's just shouting at each other in a room, and then of course, they're sponsoring bills to almost attract attention to themselves.
Right.
Right? At the end of the day, I do think there needs to be some, as I mentioned before, uniformity across the board. I don't know if that happens through Congress or, some other organization. whatever the NCAA turns into, going forward, that's probably how things will happen. I don't anticipate legislation being passed by Congress in the next 6 months, surely.
Yeah, I completely agree with you. I just don't. Performative is a great way to describe it. I think that's exactly what it is. House settlement's done. Okay, let's go out and do a press conference and have another hearing. I think. I can't remember who posted. Ross Dellinger, I think, one of his tweets said this is the 14th such hearing that has happened in the last several years. Literally nothing is getting done. So
I mean, the joke sometimes is you want to get nothing done, put two lawyers in a room across the table from each other. But I think it's really politicians, right? I think we can all agree on that. If you want nothing done, reach out to your local politicians.
There we go. I appreciate that. Thanks for coming on today on a Friday. I really appreciate it. We'll do something else soon. Okay.
Sounds good. Thanks.
All right.
Again.
Thanks, Ryan. Okay. Bye-bye.
Bye-bye.
All right. These guys came on and gave of their time and energy, and I appreciate both of them so much. I really love this new feature, the show comments on stage function. I love the fact that you guys are interacting. Everybody's able to see it on the screen. That is kick-ass. You guys are able to have conversations, and even the guests are seeing your comments without me slowing down and having to pull them up. So I want to thank you guys for continuing to do that. These shows always make me feel like we're getting a little bit smarter. But we have some of the smartest people in the world talking about this stuff, and even them, they don't know. They don't know what they should be doing, right? They don't know what it's supposed to look like. And these are the experts. So I would just have everybody just slow down. House settlement was done. I did my little rant yesterday. If you didn't catch it last night, it's on demand. You could watch it right after this show. But we're going to turn the page and we're going to start talking new stuff. The show that we're having this evening, Mo and Ute and I, I'm trying to remember what the title of the show is. Let me check. Right. Let's see. So our show tonight is going to be Camp Compliance. NIL Clearinghouse slashes the athlete compensation. I firmly believe that the NIL thing is still going to continue to be a deal. It's not going away. NIL is not going to drop off overnight because the deals have to be ratified by this NIL Go and College Sports Commission. It's just going to change. The deals are going to change. There are going to be actual events where you have to show up and do certain things, but they're going to be assigned a dollar amount. These kids are still going to get money. Now, a lot of it will probably be under the table, but the process is built to try to equalize as much as possible. That's what's next. Title IX is next. Back payments in general are next. And then this nonsense in Congress. So I appreciate everybody spending some time with us this afternoon. Our show tonight is we've changed our Friday time to it's now 8 Eastern instead of 7. We have to accommodate Ute a little bit on his schedule, which obviously we appreciate doing. So we will see everybody tonight at 8 p.m. Eastern time, and we'll talk about more NIL Go and everything else. I appreciate all the conversation, all the super chats. Jason Spangler, Ryan Willie, Daniel Gygax, and Devil Frog. You guys help me, and I just appreciate you so much. And everybody get some rest and then tune up because this evening Ute's going to come in, and I know he's loaded for bear. He's got data, and he's going to try to explain why NIL Go, the College Sports Commission, how it will throttle the unmitigated amounts of money that are being thrown at athletes currently that now evidently have to stop. We'll talk about it. I disagree, but that's where we have fun. So again, I want to thank Ryan, P. Mulvaney, and Philip Sheng for coming on, spending some time with us this afternoon on another edition of the Consigliere Show. I hope everybody has a good afternoon. We will see you this evening. If I don't see you later, everybody have a great and safe weekend. If you have family that are in the military or in any of the special services, make sure you give them a special hug and a shout out this weekend. The world's a crazy place. Lots of bad stuff going on out there. And certainly the men and women in uniform, they're up against it right now with a lot of challenges. So reach out to them, send them a note, let them know you're thinking about them, because it really matters to me. Everybody have a great couple hours, and we will see you at 8 p.m. Eastern time today. See you later. Peace.